All right. This is what I'm going to do. I'm going to find her guilty as previously stated. I'm going to sentence you to 4 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I call it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, and we're off the record. Ms. Yepes, I actually gave you less than what you bargained for, because I did consider the fact that you did come in with employment. You understand?
Hey guys, welcome back to the channel. Today, we're diving into a courtroom case where Judge Boyd delivers a brutal sentence to a felonious grandmother. No mercy, no second chances, just straight up justice. Stay tuned as we break down the case, the charges, and the judge's no-nonsense approach. Let's get into it.
Calling 2021 CR 9284, State of Texas versus Elizabeth Yepes. That party is announced for the record for the state.
Marcus Sanders.
For the defense.
Robert Mallett for the defendant.
Are you Ms. Yepes? All right, you entered a plea May 9th to count 2. You entered a plea of no contest. The state waived the enhancement and count 1 without objection. According to the plea bargain agreement, punishment is to be assessed at 6 years in the prison. There's a $1,500 fine, and the state opposes your application. Have both parties had a chance to review the PSI report, state?
Not yet, but I'm working on it.
Judge, I've reviewed the PSI. It's pretty straightforward. The state was opposed based upon, I think, the prior criminal history and amount of drugs.
All right. So are both parties ready to proceed, state?
I'm ready.
Defense? All right, state, you are opposed?
Yes, Judge, we are.
Do you have any witnesses?
No, Judge.
All right, defense, do you have any witnesses?
Judge, no, I'm just arguing on behalf of my client.
All right, the court will hear argument, state.
Judge, that's correct what defense counsel said. Our opposition is based mainly on this defendant's criminal history. Looking at the PSI, it looks like she's been given a chance at probation at least twice before. It looks like in 2005, she was granted probation for 10 years on a felony in possession. And she ended up being revoked. And actually in 1993, she was given deferred and then placed on probation and got revoked. So that's twice that she's been given a chance. It looks like we played the offense down just to give her a little bit of benefit for accepting responsibility for her actions. But that's why we don't believe probation would be appropriate in this case, and we're asking for prison sentence.
All right, defense.
Judge, we understand fully why the state made the recommendation they did. Ms. Yepes asked me to speak on her behalf because I think she's kind of nervous speaking in public. Since her release on this case, Ms. Yepes, I think, has made significant strides in turning her life around. She finally got a job at Mood Solutions. She's been made a supervisor. She makes $15 an hour. I think this is probably the best job and the best situation she's found herself in. I guess for a number of years, I think she's really got her situation solidified, and I think she would benefit from the opportunity for probation with whatever terms of what was appropriate. That's obviously the most important thing. I would like the court to consider that and consider one, I think her remorse for finding herself in the same situation again. I think the TAP talks about issues that have been on again, off again with drugs in her life. We would ask the court, if the court does see fit to give her probation, to allow her to do intensive outpatient. She's very concerned about keeping this job that she was finally able to get. I think it's very difficult for people with Elizabeth's criminal history to find jobs in the workforce. And I think this company is willing to work with her. And I think it's put her in a situation where she can be a successful part of society. So that's the court to grant that.
Oh wow, what a heartwarming redemption arc. Worked for almost 3 years, got a job, even became a supervisor. Somebody get her a medal. Except, let's not forget the decades of crime, probation violations, and prison stints that came before this sudden turnaround. And now, it's all I've changed, I swear. Because nothing screams rehabilitation like waiting until you're staring down another sentence to finally get it together. All right, so, the court has a question.
So the court has a question because it says on here, guilt minimized.
I think they were talking about on her, when I looked at that, when I read that, I think they were on the type evaluation, they were talking about her drug usage.
Okay. All right, Ms. Yepes, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Did you commit this offense? All right, so I want to talk to you about your criminal history because that is concerning. I always tell people the criminal history is sort of like a credit report, but it's a credit report related to whether or not I should give you probation. You understand? So, your misdemeanor cases, this theft, you were sentenced to 32 days in jail. And I understand how that happens. People just want to get their judgment satisfied and be done. The same thing with hindering apprehension. Then we have the assault, bodily injury, family household, 90 days, theft, 44 days, possession case, 20 days, another possession case, 20 days, then failure to ID, 1 year. So this is what's concerning to me. You pick up a felony in 1992 and you were granted deferred adjudication and you didn't complete it. Why didn't you complete it?
It's very young. My husband was very abusive and I didn't do what I was supposed to do. I didn't go to task.
All right. November 2005, felon in possession of a firearm.
That was at my house when they came looking for it. So my son, my house, it's my husband's house at the time. I was charged with that.
All right. Then we have December, the drugs, 4 to 200 grams.
And he was a,
You don't remember,
I
just
don't remember,
All right. So then we have 2007. You were sentenced to prison and then you had a parole violation. It appears that you're not learning anything from your prison. Then we have 2014. So 2014, prison, paroled, felon in possession. I'm assuming these cases were ran concurrently. And now we're here. So I don't understand. I don't know if there's anything that I can do for you because you have not learned anything.
this last time I've learned a lot. I haven't worked in my life like that. I've worked now. I've been working for almost 3 years now. I was given a chance to get a position as a supervisor's responsibilities that I have to do. Something I haven't done in many years. So it's yes. I feel like I've worked for it and I want to continue to keep it. If I lose it all, then I feel like I can age and I lose my history, my background, which is not ever going to change. I won't be able to, I won't make the right time.
Ah yes, the classic I've totally changed defense. Because apparently, after decades of bad decisions, 3 years of employment is supposed to work like a magic eraser for a lifetime of crime. Cute. Meanwhile, the judge is just sitting there, trying to figure out if any lesson was actually learned through all those prison stints. But instead of accountability, all they are getting is a greatest hits album of excuses. Blaming the past? Easy. Taking real responsibility? That's the real challenge. But hey, maybe this time will be different, just like all the other times were supposed to be, right?
Right. And here's, I'm sympathetic to what you're telling me. I'm sympathetic to you getting your life in order, maybe finally. But here's the problem. The amount of drugs was a lot. And your history is awful. All right. This is what I'm going to do. I'm going to find her guilty as previously stated. I'm going to sentence you to 4 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand? All right, and we're off the record. Ms. Yepes, I actually gave you less than what you bargained for because I did consider the fact that you did come in with employment. You understand? Do not come out and do this again because you don't know who your attorney is going to be. You don't know who the prosecutor is going to be or who the judge is going to be. And you will be a habitual and your minimum will be 25 years in prison. You understand? All right. Good luck to you.
Thank you, Judge.
You're welcome. Jose Munoz.
That's my case, Judge. It's the first setting.
The classic "I'm trying to help you out here, but you're seriously testing my patience" move from the judge. It's like handing someone the benefit of the doubt, while also keeping a backup plan for when they inevitably screw up again. 4 years in prison, credit for time served, and a fine. Honestly, probably less than she deserved given the track record. The judge even reduced the sentence out of sympathy but made it crystal clear. Mess up again, and it's going to be a whole lot worse. Lucky for her, this isn't the repeat offender lottery, or she'd be cashing in on a 25-year all-expenses-paid vacation.